For years, Prince Harry has made one mission unmistakably clear, challenging what he believes are unfair practices within parts of the British media. Courtrooms became the latest battleground in that campaign, with each legal challenge carrying not only financial consequences but also personal significance. This particular case, however, was unlike any before it. It wasn't simply another lawsuit involving newspaper reporting. It was presented as a defining moment, a legal showdown that many believed could reshape the relationship between public figures and the British press. Expectations were high. The media spotlight was relentless, and the outcome had the potential to influence future privacy cases for years to come. But when the judgment finally arrived, the story took an unexpected turn. Instead of celebrating a landmark victory, Prince Harry left facing one of the most difficult legal setbacks of his public life. And almost immediately, commentators, legal analysts, journalists, and royal experts began asking the same question. What does this result actually mean, not just for Harry, but for everyone involved? To understand why this case attracted so much attention, we first need to examine what was actually being argued inside the courtroom.
Harry has lost a gigantic privacy case against the Daily Mail and the Mail on Sunday.
Prince Harry has lost his £50 million case against the...
That's come to an end today, Piers.
Yeah.
I think that's what's so fascinating.
Yeah, I agree.
He went into this case convinced he was going to win. He believed it until the end.
The verdict came down today for Prince Harry's court case against the Daily Mail, and he has been officially deemed a loser.
Harry was supposed to be in England, and Harry was informed that he had to be in England.
And it wasn't just Harry, that's important to also notice, right, John? Elton John, Liz Hurley, a lot of people were seeking damages against these associated newspapers.
The legal action centered on allegations that Associated Newspapers, publisher of the Daily Mail and Mail on Sunday, had gathered information through unlawful methods over many years. Prince Harry was not the only claimant. Several well-known public figures, including Sir Elton John, Elizabeth Hurley, David Furnish, Sadie Frost, Simon Hughes, and Baroness Doreen Lawrence, also participated in the proceedings, each bringing separate claims while sharing similar concerns regarding privacy. Their argument was straightforward. Certain private details, they believed, could only have become public through illegal information gathering. Associated Newspapers strongly denied those allegations from the very beginning. Rather than seeking an early settlement, as has happened in other high-profile media disputes, the publisher chose to defend its reporting in court. That decision transformed the case into one of the most closely watched media trials in recent British history. Over weeks of testimony, thousands of documents were examined, witnesses were questioned under oath, and both sides attempted to convince the court that their version of events reflected the truth. As proceedings unfolded, it became increasingly clear that this wasn't simply about newspaper headlines anymore. It had become a test of evidence. And in court, evidence matters more than assumptions. That distinction would ultimately shape everything that followed. But the most dramatic moments were still ahead.
This case came to light literally weeks after my surgery, when I couldn't even walk to the top of the stair.
He doesn't get the full armed protection.
Right.
He wants it, though, because he wants to make it in a royal tour.
One of the central challenges facing the claimants involved proving exactly how confidential information had reached journalists. Feeling certain that information should have remained private is one thing. Demonstrating, through evidence, that it could only have been obtained unlawfully is something entirely different. Throughout the proceedings, lawyers carefully examined individual newspaper articles, asking whether alternative explanations existed for how reporters might have learned those details. Could information have come from acquaintances? Friends? Professional contacts? Public records? Conversations overheard at social events? Each possibility mattered because civil courts require claims to be supported by the balance of probabilities. In other words, judges must decide which explanation appears more convincing based on the available evidence. Justice Nicklin repeatedly returned to that legal standard throughout the judgment. The court acknowledged that some allegations raised understandable concerns. However, concern alone was not enough. Each individual claim still required convincing proof. As witness after witness appeared, the courtroom became less focused on headlines and more focused on credibility. Who remembered events accurately? Whose testimony remained consistent? Which explanation was supported by documents rather than assumptions? Those questions gradually became the heart of the trial. And the answers would prove decisive.
I think you've got to look at two things. I mean, the judge has been remarkably brave, because to punch Harry on the nose so violently, and although he hasn't called him a liar, implies that he didn't believe a word of his evidence, was brave in the normal break of things.
Among the most discussed moments involved evidence relating to relationships between Prince Harry and journalists. During testimony, messages exchanged years earlier between Harry and journalist Charlotte Griffiths became part of the court record. The correspondence appeared friendly and informal, with both sides addressing one another casually. For the defense, those messages suggested that communication between members of the royal circle and journalists was sometimes more direct than had been portrayed. Prince Harry disputed aspects of that interpretation during his evidence. The issue wasn't simply about personal conversations. It became relevant because one argument presented by the claimants suggested that sensitive information could not realistically have leaked through ordinary personal connections. The defense argued otherwise. The court examined whether information may have circulated naturally through acquaintances, professional relationships, or wider social networks rather than through unlawful interception. That distinction became increasingly significant as testimony continued. Every contradiction, however small, attracted close legal scrutiny. Because once credibility becomes central to a case, every detail carries greater weight. And by this stage, observers inside the courtroom began sensing that the final judgment might not unfold as many had predicted. Outside the courtroom, reactions quickly became almost as dramatic as the proceedings themselves. Television presenters, newspaper editors, legal commentators, and royal analysts devoted hours of coverage to each development. Among the most outspoken voices was broadcaster Piers Morgan, whose long-running disagreements with Prince Harry are well documented. Morgan described the judgment as an important day for journalism and press freedom, arguing that the court had carefully examined extensive evidence before reaching its conclusions. Author Tom Bower also offered strong criticism, suggesting that the legal strategy ultimately failed to persuade the judge. Their opinions received widespread attention. However, it is important to distinguish commentary from judicial findings. Media personalities express personal interpretations. Courts issue legal judgments based solely on evidence presented before them. Those two things are not the same. That difference often becomes blurred during highly publicized cases. As headlines spread across television, newspapers, and social media, many viewers encountered opinions before reading what the judgment itself actually said, and the written ruling would become one of the most closely analyzed legal documents involving the royal family in recent years. Yet perhaps the most important section of that ruling hadn't even entered public discussion, because hidden within hundreds of pages was the reasoning that ultimately decided the entire case.